नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Okay, so let's continue with our discussion of Article 1, 2, 3 and 4. I had asked you all to read Inri Berubari Union. So now I am going to call on whoever has read that judgment. I want us to kindly explain to me, I'm going to do the facts myself because they're very clear, that after Sir Radcliffe drew the border between East and West Pakistan, that is West Pakistan and India on the west, East Pakistan and India on the right, on the east. After that border was drawn. Now the border was it drawn on paper or was it drawn on the ground? Drawn on the paper. Drawn on paper, that's right. So on 3rd of August, it was drawn on paper. And Sir Radcliffe said that if there is any discrepancy between that paper and what will eventually be drawn on the ground, then primacy must be given to the paper or to the line on the ground?
To the paper again.
To the paper again.
To Annexure A.
Yeah, to the Annexure A. Very good. That is, he drew it in completely on what, in Survey of India, we would call as cadastral maps. We would spread it out and you would draw it. And then he would say from so many meters to the north of this police station in a straight line to the next police station. And it would be then reflected on the ground. I want us to understand one point that comes across very clearly in the judgment. And the judge asked the question, is it a case of a settlement of a border dispute or is it cession of territory? And this is, to my mind, one of the key questions in this judgment. Is it a settlement of a border dispute or is it cession of territory or not? And remember that
Cession of territory.
Right. And remember that this was an advisory opinion. An advisory opinion given by the courts in response to a presidential reference. And we will be studying it when I come to the judiciary, which is the constitutional article dealing with it.
243.
Section 1, Article
143. Now, if you contrast our court to the American court is only a court of adjudication. So if you look at Article 3 of the American Constitution, it very clearly tells you that the American court, Article 3, Section 1 says, judicial power of the Supreme Court shall be vested in one Supreme Court. Okay? And it also tells you that the Supreme Court will not be dealing with and giving advisory opinions. It will only be giving adjudicatory. There must be an issue, it must have been adjudicated upon, and then the court will give its decision in that particular matter. So the American Supreme Court does not give advisory opinions because it's not a judicial power, it only extends to adjudication. But by the time our constitution was being drafted, the feeling was there that if the president should seek an advice, then the Supreme Court must be in a position to give an advisory opinion. In one sense, you are preempting adjudication. By saying that here is a very difficult and a contested matter, let me know beforehand what I should do so that the matter doesn't come to court and then... Now, you will see the dangers of an advisory opinion right away. And I'll come to that when I come to judiciary. But in this particular case... case, which we will study next semester, 1996. 1995 or 1996, I'm forgetting the year, 5-judge bench decision, the Supreme Court, in couple of the questions that had been referred to it, refused to give an opinion because they said, do not constitutionalize this matter, do not legalize what is essentially a political matter. Okay? And they declined giving an opinion in that case. In this round, in our later Ayodhya decision that has come out, when did it come out? 2 years ago. Yeah, 2 years ago. You will notice that the questions were far narrower. They dealt with the question of land rights, and it was capable of adjudication, and the court in fact gave a particular verdict. So while you can request for an advisory opinion, there is no duty cast upon the Supreme Court, no duty that the Supreme Court must give an advisory opinion. And as I told you, they have declined certain times giving of an advisory opinion. But in this particular case, an advisory opinion was sought because after partition, there still remained lack of clarity about whether Berubari 12 should belong to India or at that time East Pakistan. And therefore you have the famous Nehru-Noon agreement. The Nehru-Noon agreement which deals with this particular matter. Is he bound to accept the advice? No. You please look at Article 143. They will render the advice. He may decide not to act on that particular basis. Okay? But I was saying whether they are bound to give the advice. Again, the answer is no. Okay? May give. Now, so the Nehru-Noon agreement decided to settle this issue. Now, what the issue was that they had to take that Annexure A of that Sir Radcliffe's award and see whether the line drawn on the ground was matching this one on the paper or not. If that alone had been a case, then this would be a settlement of a dispute. Just like in normal property matters, you may look at an aksara and say that my property is 3 gaj ka property hai and it should be yahan se yahan tak itne gaj hone chahiye. But the revenue officer may have measured it slightly wrongly, because you know that they have those chains with those links, etc. And maybe it was incorrectly measured. Now, again, property is being sold, and at the time of mutation of property, you go back to the Tehsildar, and then he comes with his little wire and tape, blah, blah, blah. And then he says, is patta ke mutabik, you must have 3 feet here, measure karta hai, and he finds that you have only 2.75 feet. So then he draws it between you and your neighbor, and he says, nahi, 3 inches aur aapke hain. Now, is the neighbor giving you property? Do you have to buy property from him? The obvious answer is no. It was wrongly measured. Patta ka jo measurement tha was wrongly measured on the land. And if now the border shifts by 3 inches from here to there, that would be a settlement of a dispute. It would not be a ceding of property, it would not be cession of property. What you should have got on paper has been wrongly mapped on the ground. And so you go once again and you start with your measuring tape and you say, chalo, itna nahi, itna bhi aapke paas hai. And so you cut off a little more of that slice of cake or slice of land and give it to the other person. Now, the Advocate General had argued that this was only a settlement of a dispute, that the Nehru-Noon agreement did not result in ceding of property. It was only a settlement of a dispute, and therefore there was no need for any law or any amendment in this behalf. Is there any other argument that you have to put forward about settlement of dispute or cession from those of you who have read the cases?
Yes, ma'am. One more contention I would like to give.
No, only on this point. Don't go outside this point. There are many other points on this point.
He said that it is just a ascertainment of the boundary.
Very good. Exactly. That's the word I wanted. It is an ascertainment of the boundary on the ground based on what was declared. So he said the Nehru-Noon Accord merely pointed out that if you open up all those maps that Sir Radcliffe had drawn, then this line was incorrect. But that was not accepted. And if you look, those of you who have read the judgment and you look at paragraph 14, what does the court say? It says, where a dispute about a boundary, I'm reading towards the end of paragraph 14. And why I'm doing this is when you read a judgment, you must read it with this amount of care. Okay? You must read it once, twice, underline, put margin notes. Then it really, you understand the wonderful points that are being made. Where a dispute about a boundary thus arises between two states and it's resolved in light of a award binding on them, the agreement which embodies the settlement of such a dispute must be treated as no more than the ascertainment of the real boundary between them, and it cannot be treated as a cession or alienation of a treaty. Okay, this is the contention. But in actual fact, the court finds out it was not the ascertainment of the boundary, but it was actually ceding of the territory. Am I right? That it was actually ceding of the territory. It was not just trying to find Annexure A and put it on the ground. And therefore, it was a cession of the territory. Which paragraph am I talking about?
22.
15.
So this is
At
paragraph
22, the court says the agreement begins that it had been decided that India should give half the area to Pakistan. So
That's-
basically, they are interpreted in the beginning only.
Yeah, that is, you're right. That is, if you look at paragraph, we are satisfied. Look at paragraph 22 in the middle. We have carefully considered all the clauses in the agreement and we are satisfied that it does not purport to be and has not been reached as a result of any interpretation of the award, and its terms have been reached independently of the award and for reasons and consideration which appear to the parties to be wide and expedient. And 2 lines further down, it is therefore an agreement by which part of the territory of India has been ceded to Pakistan. So keeping in mind geopolitics and need for peace, they said, chalo, tum le lo. It's not a question of interpretation of that award. It's not a question of ascertainment of boundary. So to go back to my previous example, it is not कि आपके हाथ में एक पट्टा है और तहसीलदार वो लेकर नाप रहा है कि जमीन पे कितना जमीन है और आप कह रहे हो नहीं यहाँ नहीं और थोड़ा उस साइड हटके तभी वो 3 feet होता है. That is ascertainment of boundary. That is interpretation of पट्टा on the ground. This is actually भाईचारा के लिए चलो तुम रख लो, ले लो. 50-50. Okay, so it is cession. That is now established. Now that it is ceding of territory, why I am pausing here for a moment, we have another very important 5-judge bench case of the Indian Supreme Court in 1969 called Magan Bhai Ishwar Bhai Patel versus Union of India. Now, Magan Bhai's case is a true example of ascertainment of boundary and no cession at all. There's another case, another agreement, another treaty and a tribunal award with Pakistan. And what are the facts here? Let me just deviate so that this point is clear in all our minds. In the Magan Bhai's case was the run of Kutch, the run of Kutch. You know that the run of Kutch, even in the maps, it will be put like this with dots because most of the time it's under the sea water. In summer, the sea dries out and it comes up. And the run of Kutch has a very unique ecosystem. You know that the wild, the flamingos of the run of Kutch, and which is the other unique animal in the run of Kutch?
Kharkayat.
Yeah. What is its English name? Wild asses of the run of Kutch. Now, pardon? Now wild ass, yes. What happens in the run of Kutch, because it's submerged under water and comes and goes, the border was never clearly drawn there. So finally, between India and Pakistan, they decided to appoint a tribunal, and that tribunal therefore gave that award. And based on that award, the line got drawn in the run of Kutch that this is India, this is Pakistan. And then, based on that, the land got divided. And the matter came up to the Supreme Court once again in 1969, saying that this was giving away of territory to Pakistan, and how could you do it without a constitutional amendment? Because that's the advisory opinion here, that if you want to cede territory, you have to have a constitutional amendment. And the Supreme Court in 1969 in Magan Bai's case says this is a true case of ascertainment of the border, which never existed, but you are now drawing it on the ground what the border is, and therefore there is no ceding. So I'm wanting to make this point. Now, coming back to our Indru Berubari, it is a cession of property. You're deciding to give it away, and this is no question of interpretation of the Radcliffe Award at all. For other considerations, you have decided that you're going to cede away territory. If you cede away territory, what is the mechanism by which ceding of territory happens or not? So I'm going to take it up step by step. Can the Indian state cede territory or not? Can it? What is our answer? Yes. Why can we cede territory? What is the answer of the court? Why do they say yes, you can cede territory?
Ma'am, because ceding territory is an aspect of sovereignty, ma'am.
That's right. Which paragraph?
Ma'am, actually, paragraph का तो नहीं पता, मैं बाकी मैंने पढ़ा.
पता है मैं क्यों? Why I'm asking? So, you are now all second year student. Please go and get yourself an internship with a instructing counsel who beach में goes sometimes to a senior counsel's office. Okay? And if you accompany in the briefing meeting with the senior counsel, the senior counsel will say, if it's an appellate case, he will say where, which paragraph. And you won't believe it, a lawyer will pura rat kar aayega. He will say, paragraph this, yes sir, this is where it is. And you must have everything. So in the back of the brief, they have written down in that long strip that the lawyers have. Everything will be written down, which page, which para, because they will not wait 1 second more. Because every 15 minutes, the senior advocate will be briefed if it's a Monday or a Friday. You can't be sitting there, now I'll look, and all. You can't be doing things like that. Nor can you do it in front of a judge. You just can't do it. So you must come. Yes. Which paragraph? That it's an attribute of sovereignty.
31.
Who is this? Who is this? Well and come. Akanksha. Very good. 31. That is right. What then is the nature of the treaty-making power of a sovereign state? And if you read 4-5 lines further down, cession of national territory in law amounts to the transfer of sovereignty over the said property. Okay? And then, is there any other paragraph that deals with this? With sovereignty, attribute of sovereignty, any other paragraph?
Ma'am, para 29 and 30, the court rejected Mr. Chatterjee's argument saying that there is no sovereignty, that there is sovereignty in Parliament and under Article 1. So there also the court explains.
Okay, and in any other place, do they say attribute of sovereignty? Look at para 30 itself. As regards the argument that the inclusion of the power to acquire must necessarily exclude the power to cede, there are two obvious answers. Okay, that is, you have given the power to include under article, which article? Article 1, subclause 3. Article 1.3 gives you the power to acquire. but there is silence with regard to ceding. So this argument says when something is expressly given, it will not include that which has been excluded. And there is a very well-known Latin phrase for that. And that well-known Latin phrase, where does the court deal with that well-known Latin phrase?
Expresso unis est exclusive.
Yes. Very good. Who was that? Very good. Look at paragraph 27 and look at the end of paragraph 27. Okay, then the power to acquire territories, I'm reading the last 2-3 lines, that whereas the Constitution has expressly given to the country the power to acquire other territories, it has made no provision for ceding any part of its territory, and in such a case, the rule of construction, namely expressio unius est exclusio ulterius, must apply. That express mention of a word excludes that which is not expressly mentioned. This is the argument. But this argument is rejected in paragraphs 30 and 31. And the court says that every sovereign state has an inherent power to cede territory and acquire territory. And this power is there whether or not the power is expressly given or not. Please look at paragraph 30, which I think is the real paragraph which gives the answer. Read the second sentence. There can be no doubt that under international law, two of the essential attributes of sovereignty are the power to acquire foreign territory as well as the power to cede national territory. What Article 13C purports to do is to make a formal provision for absorption or integration. It may be that this provision has found a place in the Constitution, okay, etc., etc. But what the court says, thus, look at the final conclusion. Thus, on a true construction of Article 13C, it is erroneous to assume that it confers specific powers. It is only making explicit what the inherent power of a sovereign state is. So what is the Supreme Court actually saying? Whether or not Article 13C is there or not, the inherent attribute of sovereignty under international law will give every sovereign state the power to acquire as well as the power to cede. So it doesn't matter whether something is expressly said or not. Further, expressio unius est exclusio ulterius, which is that express mention of some words excludes that which is not mentioned, is not applicable because the power to cede and to acquire is inherent. It is as it meant.
Ma'am, you're gone on mute.
Have been on mute for how long?
Seconds.
Okay, seconds. Okay, that's fine. So it's also a sui generis power. So whether it is there or not, it doesn't matter, and therefore that Latin expression expressio unius, etc., is not going to apply. Now, if it doesn't apply and you have the power to cede territory, which is a sui generis power or an essential attribute of the sovereign country, then the question arises, what is the method by which we can cede territory? And the Supreme Court, in its advice, gives you two options to the government. What are the two options that it gives the government? Anybody? Somebody who's not spoken so far in class today, please. Which are the two options that it has given? Yes, anybody?
An amendment to the Constitution, Article 368.
Okay, by amending 368, what can you do? You use the amending power.
It expresses power to the government to cede as well as acquire territory.
So using Article 368, we could amend the first and the fourth schedule, right? Alternatively, which is the other route that they give you?
Article 3, we can acquire an Article 2.
I think the court says something a little more subtle. It says you can use the power under Article 368 and physically say this territory is now no longer part of India, and you can amend first schedule and the fourth schedule subsequently. Alternatively, you can amend Article 3 to say that the power to give away territory is also explicitly mentioned. Now, why do they talk about Article 3 here? And why aren't they talking about Article 1? Why do they not give the advice to amend Article 1, like you have Article 1(3)(c), which gives you the power to acquire territory? They could have also suggested that you use Article 368, amend Article 1, and say that the Union of India includes in its territory Article 3(1)(b), for example, all territory acquired less article which is ceded away. They don't give that advice. They say either you directly use Article 368 and give away this territory, or else you use 368 and amend Article 3. And under Article 3, it is talking about new states. So you can take away law from states, and instead of adding it to another state, you can give it away to another country. You can do one of two things. Now, my question to you is, first, let me take the simple question first. Where exactly does the court give this advice? Which paragraph? No, it's not 32. If you look at paragraph 44 and paragraph 45. Now look at this point. Please follow what I'm reading out for those who don't have the cases in front of them. 44. Therefore, our conclusion is that it would not be competent to Parliament to make a law relatable to Article 3 for the purpose of implementing the agreement. Under Article 3, if you're diminishing the area of a state, increasing the area of a state, altering the boundary, altering the name, you can make a law under Article 3. Why don't I use the word amendment? Why do I use the word law? Because Article 4 tells us any change in the boundary of a state which results in consequential amendment to the first and the fourth schedule will not be treated. Okay, so let's continue with our discussion of Article 1, 2, 3 and 4. I had asked you all to read in...
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा। कमेंट बॉक्स में अपना फीडबैक देना ना भूलें। थैंक्स फॉर वॉचिंग।